Morning, Your Honors. May it please the Court. Gary. My name is Robert G. Black. I represent Mr. DeFranco in this matter. Essentially, we're here before Your Honors following a ruling on summary judgment by the Circuit Court, where the Circuit Court took loan documents that use the word guarantee and took a statutory provision that uses the word surety and said, I'm going to enter summary judgment because the Surety Act does not apply. The Appellate Court looked at this case and in terms of statutory interpretation discussed decades of law concerning surety versus guarantee. It discussed how the terms have been intermixed for years, discussed how essentially the matter is boiled down to a surety being the broader term and the guarantee being the more specific term, that a guarantee is in fact subsumed within the surety, that there is no practical reason to continue any differentiation there. And it did also comment that in terms of the documents here, the loan documents that the bank is relying upon, if the bank continues to want this bright line demarcation between surety and guarantee, then their own documents either eviscerate any such distinction or show that Mr. DeFranco was a surety. Okay? Our posture here before this Court has changed somewhat in that the bank has raised for the first time in briefing before this Court, and not in the PLA, that the essential determination here of legislative intent must be what the legislature meant and intended in 1874 when they passed this statute. And then their corollary position that we can unequivocally determine what that is by a few cases that are out there, including the Gridley case, which talks about a guarantor is not a surety, or vice versa, I'm not recalling which, in dicta, which was not relevant to the Supreme Court deciding that case in 1874, and based upon other commentary during that time, that we can definitively discern what that legislative intent was back then, and that legislative intent trumps everything else, including 135 years of case law, decisional law, commentary, restatement, including the fact that obviously our commercial system, our banking system, is dramatically different at the beginning of the 21st century than it ever was in 1874. So there are problems with this position that we have identified. First and foremost, that it ignores all of this case law that says basically the only distinction here is one of academic purposes, that essentially the surety and the guarantee both do one important thing, and that is it guarantees the performance and the payment of debt of a third party. The only real practical distinction is how that contractual relationship arises. For what was traditionally deemed as a surety, it arose in the first instance at the same time of contracting. For what was traditionally deemed as a guarantee, it arose secondarily to the contracting and arose because the guarantee would then guarantee the payment and performance.
So your argument is that these terms are synonymous?
My argument is the same that the Appellate Court accepted and the same that we've advanced, that any practical distinctions between the two have long since gone by the wayside, that in fact the surety is the broader term and the guarantee is subsumed within the term surety. Yes. What the bank's argument also ignores is how can we definitively discern exactly what the legislative intent was in 1874, and again, how does that trump everything that's been in existence since then, but also, and perhaps most critically, is that it doesn't take into proper account their own loan documents. Their own loan documents contain specific language that, as the Appellate Court commented, either eviscerate the distinction that they want for purposes of the statute or declare Mr. DeFranco a surety, or at a minimum raise issues here that were not worthy of decision by summary judgment. There is, on that point, there has been a contention in the bank's reply brief that we have somehow abandoned our position in what the appellate court said in terms of how this matter arises in the statutory interpretation. We are fully on board with how the appellate court viewed this as a matter of statutory interpretation and the fact that there is no practical distinction anymore between the two. But if we are to look at the documents themselves and how those documents are phrased, and to look at the documents within the business credit application and agreement, and that's begins at page 824 of their appendix. On the second, or it's the third page actually, which contains what purports to be Mr. DeFranco's signature, significantly it does state, and I'm trying to read it because the font is rather small, but it basically states that the confirmed loan terms, along with the signed business credit application agreement, shall be collectively considered the note and security agreement. Significantly, in this portion of the loan documents, it doesn't mention additional guaranteed terms. Within, or right above there, and underneath Mr. DeFranco's purported signature, it states that each guarantor jointly, severally, and in solito and unconditionally guarantees payment at any time. If the bank wants to still rely upon these distinctions between surety and guarantee, I think we can kind of develop a checklist of what was involved with surety vis-a-vis guarantee. And specifically for a surety, a surety becomes jointly and severally liable, contracts at the same time as the primary obligor or debtor, is answerable in the first instance, and is liable without notice. What we have here immediately shows how this is a surety setting, or evinces a surety setting, in that the contracting was at the same time by all the parties. And in that we have this language here right up front that says jointly, severally, and in solito. That is, strictly speaking, what has been traditionally deemed surety language if we're going to continue to make that distinction.
Mr.
Yes, Ron.
Feinman mentioned there's a judicial admission with respect to Mr. DeFranco indicating he's a guarantor.
We don't believe that that's a judicial admission for several reasons, Your Honor. Number one would be, as the cases have recognized, the terms have been intermixed and intermixed often. They were utilized in this case not in terms of making a distinction between a guarantor and a surety, but to follow the documentation and the language that was contained within the documents here. But beyond that, we still have contractual language here that says you're going to be jointly conditionally liable, you've contracted at the same time, all the traditional indicia of a surety. Within that section also, it also talks about how the obligations of each guarantor are independent, and each agrees the bank may proceed against one or more without proceeding against the company or other obligor. Once again, we are looking at what is traditionally surety language. Paragraph 19 within the confirmed loan terms then states the bank may take action without the consent of or notice to anyone. If we go back to our little checklist and there is actually going to be a distinction between a surety and a guarantee, once again we're checking off surety, because a surety is someone where there can be a proceeding without notice. Now let's then come to this additional guarantee terms that Gary and the bank has raised. And we've raised several concerns with the additional guarantee terms and how the record may not be fully fleshed out as to these additional guarantee terms. Number one, the additional guarantee terms were not attached as an exhibit to the complaint. There was the demand for a bill of particulars, and what was received at that point was incomplete. We don't know what, if anything, may still be said within the remainder of that additional guarantee terms because it cuts off at the bottom of the page. We can't allege, we can't assert what else might be within that because we just simply don't know. But more pointedly here, the bank's own documents say that the entire loan agreement consists of the confirmed loan terms and the business credit application and agreement, and is completely silent as to anything else called additional guarantee terms. Also, no separate signatures on there, but even more pointedly, when the bank came back to try and say that it had completely complied with providing the documents here, it didn't attest to the accuracy of everything or that this was complete, or it didn't attest that this was a part of it. What they said was, we lost the original. So the problem here then becomes when we've got this waiver language that's subsumed within the additional guarantee terms, what is our record like in terms of reliance upon the additional guarantee terms as it exists today, where we have documents that say the loan agreement is A and B and not C, but in the record is A, B, and C is incomplete. Beyond that, if we're looking to the terms of the additional guarantee, and if we're able to do so, we can see that, yes, there is, as the bank has pointed out, a section says this is a guarantee of payment, not of collection. But it also then reiterates, once again, guarantor shall be liable jointly, severally, and in solito with the company and all other guarantors of all or any part of the note, and the release of one does not affect the liability of the other. If we're still going down that surety checklist, once again, we're checking surety. It does state within paragraph 6 that in the event of any default in the payment or performance, the guarantor shall, quote, without notice or demand, promptly pay the amount to Bank One. If we're going back to that checklist, we see again without notice, indicia of what has traditionally been known as a surety. Or at the very least, raises a mixed bag here, but still evinces a surety setting if we're going to continue to make that distinction that the bank wants under the statute. The waiver language itself basically asserts, and what I suppose is confusing to me, is it says you're giving up all defenses that belong to guarantee or surety, but we're calling you a guarantor anyway. It then goes on to state within subparagraph D of paragraph 5 that any defenses given to the guarantor at law or in equity other than actual payment of the note are being waived. Several points here, Your Honors, and as Your Honors have identified, is that this particular issue of this contractual language was not raised in the trial court, was not raised to or addressed by the appellate court, but most significantly was not included in their petition for leave to appeal. I recognize that that setting, in terms of omission from a petition for leave to appeal, is more a restriction on the parties and certainly not an admonition or a definitive thing for this court here. But the fact of the matter is there is clear case law out of this court, and the case law is legion, that if you don't raise the issue in the petition for leave to appeal, you can't raise it for the first time before this court. This is when they are raising this argument for the first time, is in the briefing before this court and not in the petition for leave to appeal. But going beyond that, that waiver language itself, we do have to note the plethora of terms and words and documents that the bank has provided. And that anything that the bank has provided here should and will be, well, should be, I won't be presumptive, should be construed against the bank itself. And we have the case law that says that if it's going to be a valid contractual waiver, it's got to be knowing, voluntary, and intentional. And we submit that this little portion within a page of the additional guarantee terms that are incomplete of record and may perhaps not have been part of anything, we don't know for certain, does not constitute, and within the font that we're dealing with here, does not constitute a knowing, complete, voluntary, intentional waiver. The bank has cited the City National Bank versus Ryman case that, the statute, Section 1 of the statute can be waived. What we have asserted or want to assert in response there is that the language in that case was far different and far more specific than what we have here. The language in that case talks about, or it specifically mentions, waiver of diligence in collection. Section 1 of the Surety Act basically says, using the term surety, if you are aware that the primary obligor is going to leave the state, become insolvent, those types of things, you can give notice of that to the bank. The bank then should proceed with due diligence once the cause of action accrues to collect that. Okay? This language from City National Bank versus Ryman specifically mentions an express waiver of diligence in collection. I don't read all the additional guarantee terms here, particularly this one that broadly states you waive any and all defenses that are available at law or in equity or are available to sureties and guarantees as a specific waiver of this, assuming that this issue can now be considered. But,
Mr. Black?
Yes, Your Honor.
Let's go back to the Section 1, the plain language of the statute.
Yes, Your Honor.
Their argument is that it refers to sureties expressly. There's no reference to guarantor.
Correct.
He cites Gridley. You respond to it in yours, and you make a statement which I'm not sure I understand in your brief on page 33, where you say there's no statement in any of the cases the bank cites as being, quote, current with the enactment of the Surety Act to indicate that any differences between the two terms would also equate with an intended difference in a statutory defense to an obligation to pay the debt of another in the use. So what do you mean when you say current?
I think what we were trying to differentiate or point out there, Your Honor, is the statute certainly was enacted in 1874, and obviously we don't have the benefit of legislative history or anything from back then. The Gridley case was decided, yes, in 1874. Was it decided after the statute was enacted that year or not? We don't know. But then what we have then is a series of cases after that, culminating in a 1907 Illinois Appellate Court decision, which, as Your Honors know, is not precedential but merely persuasive, talking about this type of distinction. And in Gridley, the distinction, we believe, did not have to be made under those circumstances, and certainly was not made in reference to any sort of statutory right or defense. Gridley had at issue a guarantee situation, and the court went on to say basically a guarantee is not a surety or vice versa. And again, I'm sorry for my lack of recollection of which is which there. But it is what we assert to be in dicta in that case, and was not germane to that court's decision.
But the Gridley court does, so you are saying the Gridley court does make a distinction. You just don't think it's central with the case.
The Gridley court just says a blanket statement without justification, rationale, or anything behind it, and without citation, if I'm recalling it correctly, that just says a surety is not a guarantee or a guarantee is not a surety. That's essentially what that case says. Going back to the whole legislative interpretation here, what we have also asserted and what the appellate court did touch upon and agree with is that what we have here is essentially a provision that says if you are contractually responsible for the debt of another and you know that that party is going to become insolvent or is going to become or move out of the state, I think is the language, you can give notice of that to the bank. And I think the statute also talks about the timing of it being from the accrual of the cause of action, and that's the point that the appellate court remanded for. And if the person does that, then that person can be discharged from the obligation. In terms of how that statute comes about, I've heard bandied about surety versus guarantee, guarantee of collection versus guarantee of payment. But what is I guess, significant to me is that this statute itself talks about accrual of the cause of action. And does there need to be an accrual of cause of action if it was, back in 1874, strictly speaking, a surety, if we were to maintain those distinctions? But better answer there is that when we have this contractual relationship for the payment of another party's debt or performance of another party's obligation, one arises primarily, one arises secondarily. If you're providing a party with the incentive to give notice of something, and if the other party must act with due diligence in collection, that there exists no reason to differentiate rights and responsibilities based upon surety versus guarantee. I see the red light is on. If there are any other questions, Your Honors, otherwise, I thank you for your attention and for the opportunity to appear in front of you and address this case on behalf of my client.
Thank you, Mr. Black.
Thank you, Your Honors.
Mr. Feiderman.